2026 is probably the biggest year for renters' change.
Landlords are leaving the rental sector at a higher rate than ever.
What if we drive all these private landlords out of the market? Where will tenants live?
Well, I think that's unfortunately going to happen.
The Renters' Rights Bill brings forward the most significant changes to the sector for nearly 40 years.
When my landlord client got in, there were holes in the wall, there were holes in the floor, they were pouring water down to the floor below them.
Before we get into today's topics, over 98% of our viewers are not yet subscribed to the channel. It's a massive help to the channel if you can subscribe, and it helps us produce more content like this. So if you could double check, see if you're subscribed, that would be a great support. Now, let's get on with the show. Welcome to another episode of Is That Legal with me, Paul Britton, hosting Britton and Times Solicitors' very own podcast. I'm joined today by Sophie Campbell-Adams, a expert property solicitor. Welcome, Sophie.
Thanks for having me, Paul.
Do you want to tell us a little bit about your background to get started?
Yeah, of course. So I am a solicitor. I'm a director at Britton and Times Solicitors. I became a solicitor because, well, it was a bit of a fallback career, to be honest. I originally wanted to be an actress. Hadn't made it by 16, so I thought probably should get a career now. Fell into law A-level, really enjoyed it, was quite good at it, and I thought, well, I like Legally Blonde, so why not make this into a career? During my training contract, that's where I discovered my passion, love for property litigation, and never really looked back.
Well, that's funny because that's quite a common route into law. A lot of people that I speak to end up in law even though they had a different passion to start with. Well, I'm glad that you found property litigation great because that's what we're going to talk about today. And there is one bill that's on everybody's lips at the moment when they're landlords and tenants, and that is
the Renters' Rights Act 2025.
Yes, 25, but it's really kicking in this year, isn't it? 2026. Tell us about it. What is it?
So, 2026 is probably the biggest year for renters' change since probably they got rid of Rent Act tenancies back in the 1980s and maybe a bit of change during COVID, but this is certainly the biggest change. And I would say this is probably the biggest reform of tenants' rights. They are getting a lot more protection, I suppose a lot more security, and there's lots of changes coming in.
Are they getting more security though?
Well, they are getting rid of the Section 21 notice. Now, that was the notice that landlords could use to get their tenants out quickly, or as quickly as the courts would allow.
If they were in arrears?
No.
No.
This is just the fixed term has come to an end. The landlord has complied with all of their legal obligations, providing them with a gas safety certificate, for example, securing a deposit if there is one, and other processes like that. If the landlord had done all of those, they could serve their Section 21 notice, giving 2 months' notice, and if the tenant didn't leave, they could then start the accelerated possession proceedings.
Through the courts?
Through the courts, and get that court order saying the tenant must leave.
But now,
Section 21s are going. They're not quite gone. The last date that you can serve a Section 21 is the end of April, so 31st of April, because as of the 1st of May, they're gone.
Right.
Can't use them at all.
Okay.
So the Section 8 is still staying, but they are introducing and tweaking the grounds. So, as you mentioned, the one that's coming in is if you want to sell the property, you can rely on that ground to get your tenant out, but it can't be used within the first 12 months.
So it'll be a new carve out in Section 8.
Yeah.
I want to sell my property.
Yeah.
But you can't use it for the first 12 months.
Correct.
So a tenant will at least get
They
12
know
months of enjoyment.
Yeah. The tenant knows that they're going to be there for 12 months at least, unless they want to move, of course, or there's another reason. One of the changes that they're making is to the rent arrears, which is often the most commonly used ground. Now it's 3 months worth of rent arrears.
So the tenant has to have stopped paying for 3 months, not a penny.
Yeah, not a penny for 3 months.
Right.
Historically, it was 2 months. So they've upped it by a month. And also they've increased the notice period. So historically it was 2 weeks, now it's 4 weeks. So again, the tenant's getting more time to either not pay rent or more time to leave on the other end.
What are you seeing landlords doing at the moment, your landlord clients?
So the landlords that are planning on keeping their properties, at the moment they're gearing up for the changes. So they're making sure that they're looking at their tenancies and making sure that they remove any reference to rent paid in advance, because that's being capped now at 1 month. So before you could ask for 6, 12, now it's 1 month. That's it. Looking to see what the pet clause is, because now you can't just, they've stopped the blanket ban of pets, and you can't unreasonably withhold consent to have a pet. They should be looking to make sure that the rent review clauses are removed, because now there's no contractual right to increase the rent. You must serve a Section 13 notice, which is the prescribed form to increase the rent. You can only do it once a year, and it must be up to the market value. So really it's a case of checking your tenancies are up to date. There's also an information sheet that the landlord should be serving on their, or giving to their tenants, so making sure that's being done, and just making sure that they're aware of all the changes, especially with eviction.
So if you've got an existing tenant, do you have to send them a new contract, or do they just move over to a new agreement?
You don't have to send them a new contract. It will just automatically change
To a periodic tenancy.
And you also must give them written key terms of the tenancy itself.
Of the tenancy that survive?
Of the current tenancy.
Yeah.
Yeah.
Okay, well that's interesting. So in some ways you do have to serve them a new agreement, but
it's more of a summary.
It just summarises the ones that survive, because obviously rent review won't survive.
Yeah.
So it needs to be a document
Term
that says
won't survive.
these do survive in term. Yeah.
Yeah.
Okay, well that's interesting. So another thing that has been ventilated with some of our clients in London is where landlords generate significant income from their tenants, and the tax position.
Yeah.
What's happening there?
So on the 6th of April, the government are making it mandatory for landlords to register their income online. It's Making Tax Digital, or MTD for short. And so if you're a landlord and you receive income from property over 50,000, you must use this MTD process.
I mean, what is this going to end at? Is it going to drive? What if we drive all these private landlords out of the market? Where will tenants live?
Well, I think that's unfortunately going to happen. It could be that byproduct of all these, reforms coming in. Yes, the tenant is being protected, but what about the landlord?
Who wants to be a landlord?
Exactly. And I found that most of my clients are evicting their tenants now to then sell.
So you are seeing that a lot of the landlords are starting to sell?
Yeah. They don't want the hassle. They don't want the risk of the tenant being able to live there and finding it difficult to evict them because they don't have a ground to rely on. There's the changes coming to the minimum energy efficiency standards, or the MEES for short, which means that the landlords are going to have to make sure that their property is energy efficient to level C or above. And they have to spend their own money for that. They have to spend up to 10 grand bringing the property up to a standard.
What if 10's not enough?
If 10's not enough, then they'll have to apply for an exemption, and they'll have to say, I've done everything I can, but there's nothing more I can do to make this property at that level.
Is this EPC and the MEES thing?
That's it.
Is it definitely coming in?
It's coming in, not yet. So landlords have until 2030 to sort of start making those steps, start making those changes to the property. But I mean, if you've got multiple properties, you're going to have to start doing it now. That's only 4 years away.
So I've also heard that there's going to be some sort of register now for landlords.
Yeah, the catchy title, Private Rental Sector Database.
Right.
And what that is basically a list, a database of all the private landlords in England. So it will detail them their properties
When's that coming out?
later this year, so late 2026.
So by the time that comes out, there'll be like 10 landlords.
Well, it'll be a very short
It'll be a
database.
very short document. Why they couldn't just call it the Landlord Register?
Well, that would be the simple way of doing it. And
I sometimes think they try to be a little bit too clever.
they try and be, smart and forward thinking.
But then it doesn't make it accessible to the everyday person.
Then being a landlord isn't always accessible to the everyday person.
No, it's not. The other thing, I think the final thing would be the Ombudsman.
The Ombudsman.
What's that all about?
Yeah. So at the moment, if there are issues or if the tenant has issues with a landlord, there's nowhere they can go other than to the landlord directly. If they have issues with the letting agent, then they have the Property Ombudsman. So there are all these ombudsmen in place. They're introducing the Landlord Ombudsman to help deal with those complaints that a tenant has with a landlord directly, and it's supposed to resolve these issues sort of fairly quickly and without the need to go to court. So that's coming into force at the end of the year.
Do you have to use that service?
It's advisable to, I suppose, if you're the tenant, because if it can avoid court, then why not? And I would advise landlords to make use of that service also.
Did you say it was free?
Free,
Okay.
independent, impartial. It's reviewed by an independent person.
Free for landlords and tenants. So who's funding it? I mean,
That's probably the tax.
so it's the taxpayer. I mean, I think this is probably where it's going to tie in, making tax digital for landlords and the landlord register. I think it's quite clear that it's definitely signalling that if landlords think that we're not going to end up in a separate tax bracket, I think they can think again.
This is the tip of the iceberg
Yeah. Okay.
for landlords. Yeah.
So I mean, there's a lot there that landlords, it seems to be, it's very incumbent on landlords now to really get going, make these changes, move with what the law is saying they must do. What do tenants have to do differently, or if anything at all? Before we continue this episode, a word from our sponsor. This episode of Is That Legal is proudly sponsored by Oliver Lorenz Studios, your on-demand design team for B2B service providers. They're your dedicated design partner, delivering consistent, high-quality creative without the overhead of hiring in-house. Think bold branding, polished presentations, and visual content that actually moves the needle? Check them out now at oliverlorenzstudio.com. Design support just when you need it. What do tenants have to do differently, or if anything at all?
Well, nothing really. I mean, they can pretty much sit pretty and know that they are, heavily protected. They can leave a tenancy whenever they want, obviously giving the appropriate notice, but they don't have to worry about large rent in advance payments. They don't even have to worry about rental bidding wars, because that's being prohibited as well. The landlord must, as part of their particulars when they market the property, they must fix the rent.
I think a difficulty with, do tenants still have to go through referencing?
Yeah, so they still have to go through referencing. They still have to have the right to rent. They still have to treat the property in a tenant-like manner. They still have to comply with their obligations, pay rent. So those are still in force, but it's the issues surrounding that are really changing.
I think where the government are out of touch is that the paying rent in advance was where tenants would fail referencing, but they had the money. So although they fail referencing, they could pay 12 months in advance, which gave the landlord comfort to give them accommodation because they're getting paid.
Yeah.
So although it may seem clever to stop this paying up front for the year, it was actually very convenient for tenants to do that because they failed referencing. So now the situation we're going to have in practicality is that any tenant that fails referencing can't get a private rental agreement.
Potentially.
So where does that send them?
It could really open the door
Into...
And it would, well, if they couldn't get anywhere privately,
live,
they'd have to go social. Yeah.
So I just think it's another policy that's just not well thought out.
I mean, it's not a case where I don't know if they're thinking that landlords are getting double bubble. They're asking for this payment in rent and then, asking for rent on top of that. No, that's not the case. They ask for 6 months. The tenant technically doesn't then pay for 6 months because they've already paid. Most of the time, or certainly my clients that I've had, it has worked very well. There is, of course, the odd occasion where it hasn't. For example, the tenants wanted to leave because the property is in a very poor condition and they can't get that money back. which opens up doors to litigation. But 9 times out of 10, it works fine.
Yeah, that would be a frustration. You pay for 12 months, move in, and the place is falling down, and you want to leave after 3, but you've already handed your money over.
Yeah.
But then surely it just means the tenant's got to sue you,
Yeah,
rather than flipping it on its head where the landlord has to sue them.
yeah. So it's just it still results in litigation.
Yeah.
It's just, you know, however that's made up.
As a property litigator, you must get all sorts of crazy stories.
Yeah.
Go on then, tell us, what sort of things do you get?
So the most common ones involve disrepair. Either the tenant has gone out of their way to destroy the property and the landlord's been left with the bill because the tenant's run off and they've got no money.
And is that not a criminal offence?
It's not a criminal offence. Well, I mean, it potentially will. It is, but I'm not a criminal lawyer. But it's certainly a breach of the contract. Usually there are terms that say you've got to look after it, you've got to treat it, you've got to mow the lawn, you've got to, not paint the walls, you've got to not, knock down structural walls, etc.
Not have pets?
Not have pets. And so the tenant's got to comply with those. If they don't, then absolutely the landlord has the right to pursue them for damages, keep part of the deposit, if not all of the deposit. But again, there's always going to be that shortfall.
What's the craziest story you've had?
So it wasn't, this isn't really crazy. It's just sad. I felt so bad for my landlord client. They were a lovely person. Couldn't do enough for their tenants. But unfortunately, this one tenant got this, I think there was a bit of paranoia involved, but they got this idea in their head that the landlord was committing all types of tax fraud and planning fraud and cross-country drug running, you name it. This tenant was convinced that their landlord was involved in it and started to make their life a living hell. Started stalking them, harassing them.
They harassed their landlord?
Yeah, they harassed their landlord. Landlord tried to get them out, got them out. They came back in.
How'd they get back in?
They broke back in.
Okay.
They broke back in.
Yeah. They become trespassers.
They become trespasser. They did leave at that point, but then they sued my client for an injunction to let them back into the property. So then my client was pulled into litigation for months, the best part of a year. I mean, when my landlord client got in, there were holes in the wall, there were holes in the floor, they were pouring water down to the floor below them.
To damage the structure?
It was a 2 up, 1 up, 1 down.
Right.
And there was a tenant below them. So they were just pouring water, flooding the downstairs apartment.
Outrageous.
It was a disaster.
Yeah.
And my client had to go, I think we were in court in litigation for almost a year and a half.
Right. So who would want to be a landlord?
No, not me. I mean, I've also had clients where the landlords are a bit, out there and a bit odd. I spoke to one client the other day and he'd been served a Section 21. Fine, he was happy to go, but just wanted to make sure that, what his rights were. And he said that the landlord would just pop round, sort of give him a text and say, oh, I'm going to pop round, and then be there for 8 hours. 8 hours. Just pottering around.
In someone's home.
In someone's home that they pay rent for, they've got exclusive possession of. There's terms within the contract that says the landlord can't just, come round. And she'd pop round and be like, oh, I'm just going to do the gardening.
So what sort of property was it? A house? Or
It was a house, yeah. A house with a garden.
like a detached or?
I don't know if it was detached or semi-detached, but
There was a garden.
It was a house. There was a garden.
So what would you have to do? Stop the landlord then?
So
Or they just left, or what?
well, absolutely. As a tenant, if you're paying rent, if you're
Quiet enjoyment of the property.
quiet enjoyment of the property, if you're complying with your obligations, then you have quiet enjoyment of the
I wouldn't
property.
mind having a landlord that would come and do. It might be like a reason to rent if my landlord would then come and do my gardening for me.
You've got a much bigger garden.
Yeah,
than most,
it'd be an
though.
extra pair of hands, wouldn't it? I don't think I'd be worried about that. We're like, come on, let's go down the greenhouse.
Would you want them there for 8 hours though?
Yeah, but actually, while you're here, let's do some weeding. Got some trees that need to go in. I'd have loads of jobs for them. Maybe I should start renting again.
I was going to say, maybe you should.
Who was she? Send me her details. I'll rent her property. Get free gardening services. Every cloud has a silver lining.
You got to look for the positives.
Yeah. What other stories have you got?
I think one of the ones that really sticks out to me was, it was a mixed-use property. So part of it was a hotel.
So that's commercial.
Commercial, yeah. and then the bottom half or the other half was residential.
So
mixed use.
which does it fall under?
Exactly.
Because we all know in a commercial one, you can just boot them out.
Yeah.
They've got very little rights.
If the tenant's done something wrong,
Yeah.
they've stopped paying rent, then you can peacefully re-enter and change the
Re-enter,
locks.
forfeiture, that's right.
Forfeiture, that's the one. That doesn't quite work for residential.
No.
So if it's solely residential, you have to get your possession order. So Section 8, Section 21, as we discussed. If it's a mixed use, so you've got the commercial and you've got the residential element, regardless of which tenant you want to get out, so the commercial or the residential, you must get an order for possession.
Yeah, so then in some ways it means that the commercial one has now obtained more rights.
Yeah, they're a bit more protected.
Because it's a mixed-use agreement.
Absolutely.
Yeah.
Absolutely.
Costly.
But in this case, the owner of the hotel leased it to a chap.
Yeah.
So they became the landlord. My client became the landlord. The tenant was the tenant. But then my client also lived in the property as well. So they were
the landlord lived there as well.
So it was, the building had two landlords and two tenants.
Yeah.
But each were the same.
So the superior landlord that had the ownership of the whole block, and then he lived there alongside the commercial and residential that he'd rented it out. So it's mad.
Yeah.
Yeah.
And I mean, this was a case where the agreement was drafted by them without any legal input, so it was not fit for purpose, not worth the paper that it was written on, and they fell out with the chap that they rented to, and then it became this difficult position of, well, we want to get them out, but we can't because we need an order, but we live there, so why would we need an order when we want to evict them, but we live them? It was very bizarre.
And they can't peacefully re-enter the hotel element because of this mixed use.
But even though they're the ones that are living there, so they're not being impacted.
No.
Actually, they want this.
Yeah. What a nightmare.
It was. It was
costly, no doubt.
It was costly, and it's a shame because the reason why they let it to this chap in the first place was because they wanted to continue to make money during the pandemic. They didn't know where else to turn. They didn't know what to do, so they trusted this guy. When really they could have actually just done that themselves. They could have let it out to the workers and people needing to stay for short periods of time.
So what would the solution be? Either let it out commercial.
So do that themselves. So continue to run the hotel as they had and live there. Continue to run it as they had previously, or enter into, I would say, two.
Or move out.
Completely.
And then just rent the whole block.
Rent the whole block.
Unit.
Or enter into two sort of well-drafted agreements so everyone knew where they stood.
Okay. Right. So what would your top 5 tips for landlords be, starting at number 5?
If I was a landlord, I would first give my tenant the information sheet, which details all the changes that are coming into play.
Okay. Number 4.
Number 4, I would then send them the key written terms of the tenancy so they know exactly what is staying.
And at number 3?
I would make sure that if I'm earning over 50,000 in income, I would sign up for the MTD.
And number 2?
I would make sure that at the end of the year, I am registering on the database.
And if they don't register?
If they don't register, you're looking at hefty fines, upwards of 40 grand.
Wow. Okay. And your top number 1 tip for landlords?
If I was a landlord, I would be going straight to my property lawyer to get detailed advice about the changes that are coming in, because I need to know exactly what I can and can't do with my tenants.
I think some things are out of scope of a podcast, and you need that specialist advice.
It's a very deep dive topic for a podcast.
So they've heard it there first. Okay, let's flip it on its head. What would the top 5 tips to tenants be?
So if I was a tenant, I would be firstly looking out for the information sheet that my landlord should be giving me, which sets out sort of what they can and can't do and what the reforms are. I would then be looking out for the written key terms of the tenancy, again, to know exactly what terms are staying. 3, I would be making sure that my landlord is not asking me for payment of rent in advance, unless it's a month, but any more than that, Absolutely not. 2, I would be making sure that my landlord is not asking me to enter into a bidding war, because that's not allowed. And my final tip, if I was a tenant, I would be defending any Section 21 notice that I received on or after the 1st of May.
Well, yeah, I mean, they're great tips. I think any tenant watching this would now be well armed with the things that they should be looking at, as well as landlords. Well, thank you, Sophie, for joining us on Is That Legal today. I hope you've enjoyed the show.
I've had a fabulous time.
If you have enjoyed the show, then it's a great support to the channel if you could hit the subscribe, like, or comment in the section below. If there are any subjects that you would love to see us cover, then please let us know, because the content that we produce is for you. And that's me, Paul Britton, Is That Legal.